5 seconds to go. Start. According to the respondent number 1, the appellant number 1 detained the minor in her illegal custody in India. Therefore, the respondent number 1 filed a petition on 30th January 2020 before the Circuit Court of Benton County, USA, which, according to the respondent number 1, is the court of competent jurisdiction. The petition was filed for seeking primary care, control, and custody of the minor on account of his wrongful detention outside USA. On 3rd February 2020, the Circuit Court passed an interim order granting primary care, custody, and control of the minor child to the respondent number 1 and directed the appellant number 1 to return the child to the respondent number 1. In the petition for habeas corpus filed by the respondent number 1 in the High Court, he had stated that though a copy of the said order of the Circuit Court was forwarded to the appellant number 1 by email, she continues to detain the minor child in India. In the circumstances, the respondent number 1 filed a petition seeking a writ of habeas corpus in the High Court of Punjab and Haryana and prayed for a direction to the state of Haryana to secure the release of the minor child from the illegal custody of the present appellants. The appellant numbers 2 and 3 are the parents of the appellant number 1 who are residents of Gurgaon in Haryana. At present, the appellant number 1 is staying with them. Various interim orders were passed in the said petition from time to time. The High Court appointed a learned counsel as amicus curiae who interacted with the appellant number 1 as well as the respondent number 1 on phone WhatsApp calls with a view to ascertain their respective stands. He also submitted a report. By the impugned judgment and order, the writ petition filed by the respondent number 1 was allowed. In paragraph 55, the High Court issued following directions. Respondent number 2 is directed to return to USA along with minor child on or before 30th September 2021. In case respondent number 2 opts to return to USA, the petitioner shall bear the travel and incidental expenses of respondent number 2 and the minor child for return to, and also the expenses for their stay in USA till decision of the custody petition, and the petitioner shall not initiate any criminal contempt proceedings against respondent number 2 for inter-country removal of the minor child. If respondent number 2 fails to comply with aforesaid direction, respondent number 2 shall hand over custody of the minor child and his passport to the petitioner on 1st October 2021 or on such other date as may be agreed to by the petitioner. In case respondent number 2 fails to hand over custody of the minor child and her passport to the petitioner on 1st October 2021 or on such other date as may be agreed to by the petitioner, respondent number 1 shall take over the custody and passport of the minor child from respondent number 2 and hand over custody and passport of the minor child to the petitioner on such date as may be agreed to by the petitioner. On custody of the minor child and his passport being handed over to the petitioner shall be entitled to take the minor child to USA. In case passport of the minor child is not handed over to the petitioner or respondent number 1 by respondent number 2 on the ground of loss, damage, etc., the petitioner shall be entitled to get the duplicate passport issued from the concerned authority, and on such return of the minor child to USA, either of the parties shall be at liberty to revive the proceedings before US court for appropriate orders regarding appointment of guardian and grant of custody of the minor child. Further directions were issued in paragraphs 57 and 58 by the High Court based on a decision of this court in the case of Yashita Sahu versus State of Rajasthan. Paragraphs 57 and 58 read thus: in view of the observations in Yashika Sahu's case supra, it is ordered that till filing of any such application by either of the parties for revival of the proceedings before the US court and passing of any interim final order by the US court of competent jurisdiction on the same, respondent number 2 shall be entitled to visit the child and have his temporary custody from 10 a.m. to 5 p.m. on every Sunday. Stop.